see what we got here. Greetings. Sorry about the delay. Had a lot of technical difficulties again. For some reason, my mic wasn't popping up. Computer started freezing out of nowhere when my computer never freezes. But regardless, here we are. We're gonna get it in. We're gonna provide to you guys what you guys want, and that is more information on the Private Express Trust. So, with that being said, let's jump into it. This is not legal advice. We do not offer legal advice. This is for educational and informational purposes only. If you are seeking legal advice, please go and find yourself a registered attorney. That being said, let's get into it. So, last time we left off, we were talking about personas. And when we talk about personas, we're talking about the very things that people, living men and women, use to operate in society, in commerce. Public versus private. The persona is the public. You as the living man, woman, is the private. This is not legal advice. This is strictly entertainment, informational purposes only. But just to give you that understanding, because if you don't, you're not going to be able to understand how the Private Express Trust is going to benefit you. Not in its fullest capacity, that is. If you missed part one, please do yourself a favor, go back. There's a lot of good fundamental, foundational information in part one that's going to help give you a groundwork understanding of what this is going to look like for you, because every person, or man or woman I should say, has a different situation that they're going to have to tailor their trust for. So being able to understand the etymology and the, for lack of better wording, the deception when it comes to the Private Express Trust is only going to be to your benefit. So let's get started. The trust corpus. The corpus is the body of the trust, i.e. the property being held in trust for the beneficiaries, the very subject matter of the declaration. It should be noted that virtually anything may be held in trust. However, there are certain things which, given their innate traits recognized in law, make for better subject matter, so to speak. Anything, so we go to footnote 26. The thing held in trust is referred to as the trust res, the subject matter of the trust. So when we talk about the United States having the jurisdiction, subject matter jurisdiction over its citizens, it's the same exact thing. The trust has subject matter jurisdiction over property conveyed into it. Only difference is one is a private common law jurisdiction, and the other is a public statutory admiralty maritime jurisdiction. You can, like it says here, like you can place anything in trust. It's going to give you a really good example of how the gold, the law of the land, or the substance of payment in the republic, the law of the land, so to speak, is a very, very good material to place into trust. That being said, it doesn't have to be that. Anytime you convey something into trust, if there is a legal title to it, you want to make sure that you have that before you do it. Otherwise, I can place a house into a trust. I can place a car into a trust, but if I don't have a legal title, was there true ownership had before I conveyed that into the trust? No. It might open up an opportunity for your trust to be brought into the public. And that's not what we want. So we want to make sure that we have full legal and equitable title. We're going to talk about those titles here in a little bit more when we talk about certificates. But that's very important to realize. Like, for example, we talk about them. What's a good example? Marriage license.
Amazing.
Here's the thing. It's a three-party agreement. It's a trust. You, your spouse, and the state. Literally. And when you get divorced, the court has to say so over all of the property that came from that marriage. First being you two, and how you guys are supposed to govern yourselves throughout the divorce proceedings. And then also your children, if you had any joint purchases, any joint bank accounts, such and such, etc., etc. If you are someone that wants to operate in the private marriage trust, common law marriage trust, versus the public marriage license, asking for permission to do something that was already an inherent right for you to do, then you should go get a marriage trust, a common law marriage. I don't know what it's going to look like. Depends. What do you want in your marriage? Are you a polygamist? Are you something else? Are you not? Like, it just depends. So like, let's just say, okay, I'm getting married to he said, she said, whatever. Such and such, hereby covenant their mind, body, and entirety into this trust through holy matrimony, etc., etc. All property exchanged or purchased with permission. Like, it can be so many, I don't want to go into anything. It can be worded so many different ways. And that's the thing, some states will recognize your common law marriage. Some states will, some states won't. But regardless, we're not trying to ask the state for permission anyways. We don't want the state. We want to be independent. That is why we're operating through trust. We're saying, okay, I'm going to take affairs in my own hands. I'm going to stop asking for permission, and I'm just going to do it. And this is a edifying word to you out there. Anyone out there that's questioning yourselves in regards to being able to do this. You can do this. I'll say that again. Anyone out there that's thinking, oh, this might be too much for me. You can do this. We believe in you. You can get this done. Start with the root etymology of the words and then level up from there. But yeah, you can form a trust around anything. You can place anything inside of that trust, so long as you have full legal title. Let's continue. True legal title. So when we talk about cars, we talk about manufacturer's certificate of origin or manufacturer's MSO. I can't remember what the S stands for, but it's something else. That's going to bug me. Okay, let's continue. So we understand that we can place any property into trust as long as it's fully owned. Initially, the legal minds who perfected the express trust in America did so to accommodate for the great obstacles in procuring special charters for corporations intended to deal in real estate, which trust eventually came to be known as the Massachusetts Land Trust. It was when those individuals came to realize the immense benefits of employing the trust for the purpose of holding land that they eventually expanded their utility to include the holding of personal property. These eventually came to be known as Massachusetts electric companies. As an aside, when considering the presently hostile official attitude towards non-statutory trust, what is interesting to note that much of the express trust perfection is attributed to Attorney General and later United States Secretary of State Richard Olney. But the fact that the express trusts were initially primarily utilized for purposes of holding and handling real estate is very significant, especially to our present situation. So what is that saying? Well, it's saying, it's going to explain why trusts are so good for holding land here in a second. I don't want to go too far ahead. But the reason why, if you go to an attorney and you ask them about a common law trust or a private express common law trust or whatever you want to call it, Massachusetts Business Trust, Massachusetts Land Trust, etc., etc., why they're going to look at you like you're stupid, like it's a conspiracy, like it's taboo, is because this is a private entity. It's private. Attorneys aren't private, they're public. Why are they public? Because they work, go look up officer. Let's just look it up. Officer, see if we get anything. We gonna get anything? You know what? Maybe we should look up an attorney instead, so people can see this. Because people need to know this. Because everyone thinks that the attorney has the best interest out for them. Best interest in mind for them, which is not necessarily true for all attorneys. There are very good attorneys out there. But people need to see this if it's going to. Ah, man. I don't know if I'm going to find the definition I'm looking for. The word attorney means to turn over. So it's already contradictory to go to an attorney for a common law trust, because it's your natural right to create a trust because it's a right of contract. So when you go to an attorney, to turn, you're turning over. That's what attorney means. You're turning over. But when you consult an attorney, what are you turning over, so you say? You're turning over your rights. I'll say that again. You're turning over your rights. Why? Because attorneys are public officials who work for the public. Their first duty is to the courts. It's not to you. They will tell you that if they're not working for you. They're not going to tell you that once they got you knee deep, got you $10,000 deep in a case, and at the end of the case, they're just going to help the state out anyways. I'm not going to be able to find it, but I hope that makes sense. That's why there's a hostile attitude towards non-statutory trusts, because they're public officials. Attorneys are public officials. Judges are public officials. These private express trusts, being in the private, can't be underneath the jurisdiction of the public. They can't be taxed like public entities unless you incur that liability upon yourself. They can't be pierced by public courts, by courts of admiralty maritime, unless you bring that liability on yourself. And if you do that, maybe you shouldn't be a trustee, because they don't have jurisdiction over it, because it is created it is not a creature of common law, but created through the common law of contracts, as we're going to read here in a little bit. That is why there's a hostile attitude. That's why they want it to seem taboo. They don't want people to be great. Think about it. They tell you trusts are for rich, wealthy people. Well, that's only 5 to 10% of people, if that. It's not for the poor. But who's the biggest group? It's the middle class. They try to make it seem like you can't have a trust if you're not making over $255,000 a year. It's not true. It's not true at all. Why is that? Because they want those classes separate. They want that disparity to grow. Who's they? I don't know. This is not legal advice. This is entertainment, informational, for purposes of those sort only. But I don't know. If you can keep the tools of the rich in the hands of the rich, then you can grow that disparity and gain more wealth. When the middle class start to operate on a trust, and they limit their tax liability, and they protect their family assets, and they avoid probate court, and they do all these other things that are draining money from their families while they're struggling to keep their heads above water, now they start to catch up. Oh, now they're starting to learn because they're catching up. Oh, now all of a sudden, we just went from middle class to upper middle class. And then the next generation just went from upper middle class to, we're well off now. And then we're wealthy. And then all of a sudden, 5 generations down the line, we got billionaires. Because everyone learned how to operate on a trust. We got our family on a new wave. We took our family out of generational curses into generational blessings. Let me get off my soapbox. Let's continue, because I can go on and on about this. The significance derives in pertinent part from the integral relationship between the law and the land. It is a fundamental principle of law. that the land and the law go hand in hand. And in America, without the 14th Amendment, the law of the land is the Constitution with its common law principles and its substance of gold and silver. So remember what we talked about last time. Public versus private. That is public. That is private. Public. Private. 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 Know the difference. Private is of the Constitution. Private is of the common law principles in the light of the Constitution and not of statutory law. Public is the 14th Amendment, where you're saying, oh, well, the 14th Amendment is the Constitution. Yes, but it's the type of citizen that was created underneath that amendment. That's where things start to get abridged off a little bit. And that's where you got to understand the difference. Statutory law, rules, regulations, ordinances, public. Understand it. If you have questions, let me know. I can't offer legal advice, but I can answer a question. Please feel free. The basic principle of law holds that land includes everything of value extracted from it. I'll say that again. The basic principle of law holds that land includes everything of value extracted from it, gold and silver. And without getting too deep into the operation of common law, it is this principle regarding the relationship of land and law which, by its operation, threw up an obstacle to corporate real estate ownership. Now, how would that create an obstacle for corporate real estate ownership? How? I don't know. Does anyone know? Well, what's corporate? Corporate is a what? Public entity. An S corp, a C corp. If the land is private, how can a public entity own a private thing? You can't. Why? Because this is a fundamental rule you need to understand. You're either public or you're private. They don't mix. They do not mix. Public and private do not mix. Go watch. Yusuf Els has a really good video on YouTube about this. If I remember, I'll put it in the description box below. But public and private do not mix. Let's continue. Sorry, I want to make further that point. If public and private don't mix, and this is of the public, how can they own the land which is private? That's what I wanted to say. They can't. In order to charter a statutory civil law entity to handle the substance of the common law, which is the land we're talking about, special, if not extraordinary legal circumstances must exist. These circumstances did not exist prior to the post-Erie federal common law, whose imposition was made possible by loss of a gold standard in 1933. Title 31, USC 5118. Man, can't talk tonight. Prior to that, silver had already been demonetized in practice, but not in fact, by the Coinage Act of 1873, commonly referred to as the Crime of 73, which, it is blatantly obvious, would have been unconstitutional if done in fact. It is said to have been a tactic of Congress is public, to place in the public mind the perception of the currency as being solely backed by gold, presumably for the purpose of the eventual passing of House Joint Resolution 192, which Congress knew would affect a removal of the substance of law. Silver was later withdrawn from circulation in certain coins by the Coinage Act of 1964 and was removed entirely by amendment of the Coinage Act of 1964 by the Bank Holding Company Act of 1970. Then, all silver-backed certificates were discontinued in 1974. I want to see if they'll give me this. Let's type it in. I want to see if they're going to give us House Joint Resolution 192. If not, we'll move on. I don't think they're going to give it to us. Let's continue. A statutory entity is inherently accountable to courts of civil legislative jurisdiction. Public. Public. I'm going to drill this through your head so you understand it. Deriving subject matter jurisdiction from the corporate, public, over which the legislature, public, holds interim jurisdiction as well by way of possession of the charter documents themselves. Whereas an express trust, private, is obviously inherently accountable to courts of common law, private, deriving subject matter jurisdiction from the trust instrument and corpus, private. As logic follows, interim jurisdiction remains with the trustee at all times, private, unless the trust instrument, private, are surrendered to a third party voluntarily, public. Public and private don't mix. You're either one or the other. This is why you don't surrender. They should never be able to pierce your trust unless you want them to, or you want to play in their game to a certain degree. And even then, it's a private trust. Let's continue reading. I hope that got through. Continue to hammer that point home. This brings us to today. In the jurisdiction of the 14th Amendment, United States Public Trust, because you can have a public trust, you can have a statutory trust. Precious metal, the substance of the common law, is legally merely a commodity. Let's look up commodity. I know they got this one. And it says, excuse me. Oh, come on, brothers. Did I look this? I think I looked this up earlier anyways. Oh man, look at that. Commodity, a good that is sold freely to the public. It can be agriculture, fuel, or metals. It is traded in bulk in the commodity or spot market. So as a public good, it can be sold freely to the public, whereas in the private, it is used to pay for things. This is why the Erie versus Tompkins is so big. What footnote was that? 29? No, it's not 29. 30. No, they don't have it. Erie versus Tompkins is one of the best cases you can read. You need to go read that. It's very, very important. It's very, very important. I'm not going to read it because it would take me some time to kind of dive in. Maybe I'll do it as a separate video someday. But I got a couple other things like Hell versus Hinkle, and then there's other trust read-throughs as well that we're going to do. So I'm not going to tackle that right now. But the fact that they, what's the word I'm looking for here? The fact that they took away the gold standard and replaced it with a public method of paying for things, and is essentially, long story short, without getting into the details of it, commercialized almost everything, even the land, and caused bonds and everything to be placed on the land. You gotta go read the case. The case is really good, but that's just it. That's how it happened, without getting into the nitty-gritty details. This is why jurisdiction always remains with the trustee, too, because there's nothing public in that trust, because full ownership is had. That's why when you, like I said above, when you convey something to trust, make sure you have full ownership over it. Continuing. Back in the Republic, however, it remains the staple for payment of debts, though surface gold and silver are in considerably lesser quantity and without a fixed standard upon which to be traded. The express trust under the common law, holding real estate, silver or gold, is holding the very substance of the law which it was created, thus ensuring that bond between law and land and the powers and guarantees that come with it. Let me see, 33 down here, Bill of Rights, Amendment, 7th Amendment. So, in the public, it is something that can be sold, whereas in the private, it is power to pay for your debts. But since the gold standard was removed, and then gold was replaced with Federal Reserve notes, it made it strictly and merely a commodity in the public. In the public. Made it a public thing, if anything. If that makes sense. This is why you don't want a statutory trust. This is why you don't want, I don't want to say you don't want an LLC. You'll want an LLC for certain things. You'll want an S corp for certain things. It just depends on what you're trying to accomplish. A statutory trust, though, I think that's an absolute waste. I do not give legal advice. This is not legal advice. This is entertainment and informational purposes only. But why would you get a statutory trust giving the state an interest to your trust when you have a private express trust under the common law? Let's just think about that. Let's keep going. 33, I already looked up at 33, I think. So anything else regarding trust corpus? So again, remember, the gold is of the land. The Federal Reserve notes are of the sea. Just remember that difference of public and private. I have a chart that maybe I'll share one of these days on here. It's like side by side, what's the alter ego, or the good or bad version, the public and private version of each thing. Like man is to person as to statutory trust is to private express trust, things like that. I had a point I was going to make here, and I don't remember what it is. I wanted to read 31, where is it? It should be noted that though the express trust is created under common law, it is not a creature of the common law, as distinguished from equity, but rather it is created under common law of contracts and not dependent upon any statutes. Equity supplements the common law. It doesn't abrogate it, it doesn't get rid of it, it supplements. And though a trust may bring an action in matternity, it is not inherently accountable to that jurisdiction. Notice the word inherently. 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 Case law. Again, I'm telling you, inherently, meaning of its natural being, it is of the common law. Let's continue. Certificates. What may come as a surprise is that any trust may divide its trust property into shares and issue certificates. The power to issue certificates and bonds and employ the use of an official seal never has been restricted to corporations. We got 35 and 36. Talking about seal, it's a private thing, essentially, when used by a trustee. It's not, let's just read it, because it's going to talk about it here. It is well settled law that whatever else most corporations possess beyond the artificiality and right of suit, and a corporate name is a mere incident or consequence of incorporation, and not a primary constituent. In fact, most attributes now commonly held as corporate in nature, such as the power of issuing transferable shares, limiting liability of officers, using an official seal, making bylaws, purchasing lands and chattels, are merely the legislative recognition and adoption of natural common law rights any man sui juris may exercise without permission from the state. So what does that say? Basically, the United States created statutory entities, LLCs, S Corps, C Corps, B Corps, statutory trusts, to gain an interest into your affairs, to gain rights, to have the permission to tax, to take, to seize, to whatever they want to do, so that you serve their purpose through coercion. This is not legal advice. This is only informational and educational purposes only. That is why that happens. This is why the middle class gets taxed into oblivion. This is why the rich avoid taxes. They operate through trust. In the creation of that, they took all the characteristics of the private express trust and then gave them to corporations. We're going to cover that here more in this court case. The court in Warner versus Beers clarified this principle most effectively. There are several very useful and beneficial accessory powers or attributes, very often accompanying corporate privileges, especially in moneyed corporations, which, in the existing state of our law, as modified by statutory law, are more prominent in the public eye. Sorry, I can't talk. Speeding through. And perhaps sometimes in the view of our courts and legislatures than those which are essential to the being of a corporation. Such added powers, however valuable, are merely accessory. They do not in themselves alone confirm a corporate character. Meaning, it's telling us, it doesn't make, just because my trust has a seal or it limits liability of trustees or anything like that, doesn't make it corporate. And may be enjoyed by unincorporated individuals. Such a power is the transferability of shares for beneficiaries. Such too is the limited responsibility. So let me go back. Transferability of shares looks different in a trust compared to a S Corp or a C Corp. Difference is in a C Corp, the shareholders get say-so in a public entity because it allows more officials who work for the public to then benefit by holding shares while holding public office. We're not going to talk about that though. Whereas in a private express trust, the beneficiaries should not have any say-so, like a shareholder in a public entity would. Otherwise, it would just make them a public shareholder, and they would be liable. Let's continue. The limited responsibility, the liability, convenience of holding real estate for the common purposes, exempt from the legal inconvenience of joint tenancy or tenancy in common. Again, there is the continuance of the joint property for the benefit and preservation of the common fund, indissoluble by death or legal disability of any partner. Every one of these attributes or powers, though commonly falling within our notions of a moneyed corporation, is quite unessential to the legality of a corporation, may be found where there is no pretense of a body corporate, nor will they make one if they all were combined without the presence of the essential quality of legal individuality, aka I asked the state to create this for me. So there you have it, folks. Just because the corporation has or the private express trust has a characteristic of a corporation does not make it a corporation. Pretty straightforward there. Pretty straightforward there. Let's continue. The trustee of an express trust is empowered by the terms and provisions of the trust instrument to issue certificates not only of beneficial interest, but also of capital interest. Generally speaking, beneficial interest is that which is held by the beneficiaries of the trust, beneficial interest, beneficiary, make the connection, who is entitled to a certain proportional share of the trust assets during the life or at the termination of the trust, while capital interest is that which is held by the exchangers, who has invested property into the trust, and thus becomes entitled to a certain proportional share of any profits and assets remaining at the termination of trust. So, essentially, like, beneficiaries have the right to a proportional share and the rights of usage of trust property as well, not ownership, usage. Whereas the holder of the units of capital interest have a right to the shares of any gains that are realized from the assets or the assets themselves. Continuing. As you see here, it's very similar to what a shareholder might look like in the public, but we're in the private. Let's continue. As a rule, the terms and provisions of the trust instrument control the manner in which beneficial and capital interest are to be administered. It should define the rights of interest holders, who, incidental to their acceptance of the interest, are bound under the trust instrument to that extent. More case law. But there are certain principles which govern these interests in construing the fundamental classification of the trust. For instance, it is held that where the certificate holders hold have control over the trust property and or administration of the trust affairs, the trust arrangement is in fact a partnership in which the shareholders become liable for the acts of the trust. Why is that? Because technically at that point, the trust no longer owns it. The beneficiary is managing while holding equitable title. Equitable title plus legal title, remember this, equals full ownership. Equitable title plus legal title equals full ownership. The rights of usage, which is equitable title, plus the legal title, which is the actual title to it, the rights of ownership is full, complete ownership. So of course you would be liable for the acts of the trust. It's an alter ego at that point. Let's continue. The basic principle is that if it is free from the control of its interest holders, then it is an express trust. More case law down below. This is commonly referred to by the courts of equity as the control test, in which control must ultimately rest with trustees of the trust in order for it to be properly classified as an express trust. Notice how it says control, not ownership. Control, not ownership. This will come back up later. The well-settled principle applied by courts of equity is that interest holders, by full legal title and control over the trust property, being vested absolutely in the trustees, cannot be considered partners nor agents. Why is that? Because they don't have rights of ownership. The trustees are holding it on behalf of the trust. So the beneficiary can't be liable because they don't have the full ownership, and therefore cannot be held liable for the debts of the trust in that manner. Own nothing, control everything. It's going to come back up later. Let's keep going because we're almost there. We're going to stop here because this is a big one, big section coming up. Furthermore, the certificates have no this is a good one, pay attention. The certificates have no determinable fair market value because fair market value refers to public. That's why. And therefore, no gain or loss is recognized until the cost of other basis of the property disposed of has been recovered. We're going to talk about this. There's footnote 48. In regard to capital certificates, the courts have long upheld the doctrine of exchange, in that certificates in exchange are not taxable until a realized gain has occurred. Let's continue because I'm going to read this. In Commissioner of Internal Revenue versus Marshman, the court held that fair market value is determined by property received by the taxpayer, not the fair market value of the property transferred by the taxpayer into the trust. What does this mean? Well, if the certificates have no determinable fair market value, and that fair market value is not determined by property, I'm completely tongue twisting myself here. If the person who transfers property into a trust receives a certificate for that transfer, and it has that certificate has no market value to it, is it taxable? No, it is not. That's why. That's important. What's more, I'm going to read this because I'm going to come back to this point. Making sure I'm in the right sense. Okay. What's more is that certificates are considered not necessarily as chattels, property. Let's just look it up. Of course I spelled it wrong. An article of personal property, any species of property not amounting to a freehold or fee in land. You're owned by something, essentially, when you're chattel. But as documentary evidence of ownership and intangible rights, and in and of themselves, they are only personal property, not the actual interest or share itself. The interest in an express trust cannot be traded without the approval of the trustees. This is contrasted with the certificate of stock, which courts have long held may be dealt with in the market as a commercial document of value. Well, there you have it. If a public entity shares, their stock is a commercial document of value, quote unquote, then that will tell you that a certificate of beneficial interest is not a commercial document of value. It's just an expression of intangible rights of usage. I wouldn't say I could be wrong here. I would disagree with it saying ownership. The trust is the owner, not the beneficiary. So I think that's worded weird. If anyone thinks otherwise, please comment below or message me, whatever. I have no issue with being wrong, but that's just my opinion there. So you don't want the beneficiary to even own anything. You have rights of usage, yeah, but not ownership. That makes sense. You benefit from the trust property, but you don't own it. And yeah, again, it's showing a clear distinction between the difference of public entities and private entities. Get in the private, operate in the private. How do I say this before I close? You can do this. Learn the terminology. Assert yourself. Map out a plan. 1 month, 2 months. Let me get this down and say all of this. Search the root words. If there was a word I covered that didn't make sense, go and Google it on Black's Law Dictionary or on Investopedia or whatever. Do the little things that are going to help you learn. It's going to help set yourself up and your family up for generations. Because it's that little step that you're taking that's going to make it and create a whole different life for you and the people around you. I'm trying to think if there's anything else I got before I close this down. But no, yeah, you got this. I believe in you. You got this. If you weren't interested in doing it, you wouldn't even be listening to this right now. So yeah, long story short, certificates are given to beneficiaries or to people who exchange property into the trust for capital gains. It's as simple as that. And yeah, it's as simple as that. Beneficiaries have the right to benefit, but they should not be owners, nor they should, because with ownership comes liability. If that makes sense. So I don't really like that word there that says ownership. But I think that's about it. This section's pretty straightforward. You obviously write it into your trust document, your declaration of trust, like it says up there, how you want them to receive and what percentage of the trust certificates you want them to receive, and when they can receive distribution of trust assets. You can write it all in there. You can say never. I don't want to say never. That's not an equity. That would be frowned upon. Otherwise, the trust would have no purpose, true purpose at least. But you can say, upon this and that, upon this and that. You make the stipulations. It's your contract. You have control. So for so long, we've been conditioned to say, what does the government say we can do? No, you have the natural law of contract. Get up there and get out there and make it happen. You can do this. Other than that, I think that's about all I got. We will be live again here in a couple of days, 1 o'clock Eastern Standard Time. This upcoming Sunday, February 19th. Hope to see you guys there. If you got any questions, comments, give us a like, give us a subscribe, and we appreciate you guys tuning in for this. Hopefully, this is helping you guys. It's helping me further my foundation in operating as a trustee, and I hope it's going to do the same for you.